season of the Urban Conservative Podcast is brought to you by Newton for Senate, working to improve education, reduce taxes, and keep North Carolina #1 for business. Find out more at newtonforsenate.com.
TV, bridging communities worldwide. We broadcast diverse international content from Europe, Asia, Africa, and now right here in the USA. Watch us via Roku on your smart TV. Submit your own content to 1530entertainmentllc@gmail.com. Download the Millennium TV app from the App Store to stream our shows anywhere, anytime. Millennium TV.
What's up, everybody? Happy Sunday. You're checking out Supreme Court Sunday here on the Urban Conservative. And today on Supreme Court Sunday, we're going to be listening to oral arguments in Moore versus Harper. This is the case where the North Carolina Supreme Court threw out the maps legally drawn, according to the North Carolina General Assembly, legally drawn maps. So today we're going to listen to that argument this Sunday. We hope you enjoy Supreme Court Sunday only here on the Urban Conservative. We really appreciate it, folks. Let's get into it.
We will hear argument this morning in Case 21-1271, Moore versus Harper. Mr. Thompson.
Mr. Chief Justice, and may it please the Court, the Elections Clause requires state legislatures specifically to perform the federal function of prescribing regulations for federal elections. States lack the authority to restrict the legislature's substantive discretion when performing this federal function. As Alexander Hamilton wrote in Federalist 78, the scope of legislative authority is governed by the commission under which it is exercised. Here, that commission is contained in the United States Constitution, and it is federal law alone that places substantive restrictions on states' legislatures performing the task assigned them by the federal Constitution. The most prominent discussion of the Elections Clause in the early Republic occurred during Massachusetts' 1820 Constitutional Convention. Joseph Story, then a sitting justice on this court, explained that a proposed constitutional amendment requiring representatives to be elected in districts would violate the Elections Clause because that clause vested state legislatures, quote, with an unlimited discretion in the subject. Justice Story's view was an echo of Alexander Hamilton's father-in-law, Senator Philip Schuyler, who took the exact same position on behalf of the entire New York State Senate just 1 month after the ratification of the Constitution. And for the first 140 years of the Republic, there was not a single state court that invalidated on substantive grounds any congressional redistricting plan. This court's decision in Lesser teaches that the founders tasked state legislatures with federal functions that transcend any substantive limitation sought to be imposed by the people of the state, and I welcome the court's questions.
Counsel, this case is from a state Supreme Court that interpreted and applied a state constitution. So it would be helpful if you would take some time to explain what exactly we are reviewing, what decision we're reviewing, and what is the basis of our jurisdiction.
Yes, Your Honor, thank you. So the court is reviewing the decision. There was an order on February 4th of the North Carolina Supreme Court, and it was accompanied 10 days later by a written opinion. And in that written opinion, there was a liability determination that the Elections Clause did not apply. And importantly, there was also a remedial determination, and we can see this at Petition Appendix 142, where it empowered the North Carolina Supreme Court, empowered the lower state court to draw the maps if necessary. And so that is a final order of the North Carolina Supreme Court, and it passed on the relevant questions. In addition, there's a second final order, which is on February 23rd. There was a denial of a stay application, and that too is a final order of this court.
We don't normally review state Supreme Courts' interpretations of state constitutions. So what I'm looking for is why, for example, if this were a case about a state legislator or a legislative district, it'd be doubtful that you'd be here under the state constitution. So I'm looking for an explanation as to why this case is here and what's the jurisdiction for this case. How does it differ from a purely state case?
Well, Your Honor, our position on the merits is to take as given state law as interpreted by the North Carolina Supreme Court. We're not asking this court to second guess or reassess. We say take the North Carolina Supreme Court's decision on face value and as fairly reflecting North Carolina law. And when one does that, we see that there's a violation of the Elections Clause, and that's why we're here.
You concede that state legislative action under the Elections Clause is subject to a governor's veto, right?
Yes, Your Honor.
Well, the governor's not part of the legislature. Why do you concede that point?
Well, Your Honor, first of all, we're not here to relitigate Smiley. We're prepared to accept all the court's precedents, number one. Number two, I think the Arizona dissent pointed out that Samuel Johnson defined legislature by reference to Matthew Hale's definition, where he said the three branches of the legislature, the two houses of parliament, and the king, because it was understood at the time of the founding New York and Massachusetts had gubernatorial vetoes. So it was understood that the governor had a role to play at the time of the founding, and at least it's arguably grounded in the text.
Well, given Smiley, if your concession doesn't undermine your position, doesn't Smiley? I mean, that's a pretty significant exception. You have otherwise a very categorical case, and it's sort of well with this one exception, but vesting the power to veto the actions of the legislature significantly undermines the argument that it can do whatever it wants.
Well, Your Honor, that's a procedural limitation, and as we understood Smiley, it was talking about defining the legislative power, and here we have a separate issue. We have trying to limit that legislative power. So however the legislative power is defined under Arizona, under Smiley, we are not, we can take those precedents as given, but what can't happen is there can't be a substantive limitation.
Well, last question, at least for a while. Why do you say it's procedural? Let's say the governor is opposed to the legislative action with respect to the elections then that the legislature endorses. He's the opposite political party, has a whole different view, and says, gives a speech saying, it's wrong because of this, not because of procedure. That strikes me as saying, they're supposed to have, 2 votes on it or whatever, and they didn't, or, they need a committee report. That sort of thing is procedure. Straight out veto, we really don't know what it is.
We're proposing a formalistic test for procedural, which is it a step, a hoop that needs to be jumped through? And if presentment is one of the hoops that the state legislature needs to jump through, then under a formalistic approach that we're suggesting, then that would be procedural, Your Honor.
Sorry. Please finish. I was just going to ask, is your formalistic test just a way of trying to deal with our precedent, or are you rooting that in the Constitution itself? Because you do have a problem with explaining why these procedural limitations are okay, but substantive limitations are not.
Well, Your Honor, we certainly have tried to craft an argument that is consistent with all of the court's precedents, but we think that there are good reasons why there would be a substantive limitation, even if not a procedural limitation. We can see this in James Madison's remarks. I would refer the court to the 3rd volume of Eliot's Debates, page 367, where James Madison laments partisan gerrymandering, and he singles out one state, South Carolina, for opprobrium for their partisan gerrymander. And their partisan gerrymander was found right in the state constitution. And that's the rule that my friends on the other side are advocating for. They're saying you can have a partisan gerrymander, but you have to put it in the state constitution.
So that's not so much your argument then, this procedural substantive distinction is not so much a matter of the text, but you're pulling some things from the history and saying, like James Madison's comment supports this procedural substantive line.
Well, we ground it in precedent, Your Honor, and text and structure and history. So I'll take those one at a time, if I may.
Sure.
So the precedent would be Smiley on the one hand seems to suggest that procedural limitations can be circumscribed on a legislature, and Palm Beach County, as we read it, teaches that substantive limits cannot be placed on a state legislature. So that's the precedent. In terms of the text, I think all of us agree, Your Honor, that it's a lawmaking function. And so, and the text shows that where it says prescribe regulations, this is the lawmaking function. And so it makes sense the founders structurally would have said, okay, there's a pre-existing entity, the state legislature, and we're going to have that be bound by its procedures, but we're going to have federal substantive limitations. And you can see this with state courts.
But can I ask you a question? Can I ask you a question? Because you suggest that there's this thing called the legislature that the framers were familiar with, and I'm trying to understand why what counts as the legislature isn't a creature of state constitutional law.
Well, Your Honor, I think this court in Arizona did say that the states have a lot of flexibility in terms of defining what state legislature means, but what Arizona did not say is that there could be substantive limitations.
But well, I don't understand how that's a different thing. In other words, if the state constitution tells us what the state legislature is, and what it can do, and who gets on it, and what the scope of legislative authority is, then when the state Supreme Court is reviewing the actions of an entity that calls itself the legislature, why isn't it just looking to the state constitution and doing exactly the kind of thing you say when you admitted that this is really about what authority the legislature has? In other words, the authority comes from the state constitution, doesn't it?
No, Your Honor, it's a federal function, and we know that from Lesser. So this court in Lesser held it's a federal function. When these duties are assigned to the states, that is a duty that is assigned by the federal
Yes, it's a duty. The duty is to make this legislative determination, that is, the determination about elections. My question is, where does the entity's power come from to make any determinations at all, right? I mean, yes, I see that the federal constitution is giving them the right to make a particular determination, but they're not giving just anybody in the state that right. They're giving somebody called the legislature, and in order for us to have a thing called the legislature, we have to look at the state constitution to determine where those, what that entity's powers are, how they can be exercised. Other than that, I don't really understand how the legislature is authorized to act at all.
Well, Your Honor, we know that's not right because in Lesser, the people of Maryland tried to prevent women from voting. And the way they did that is they put in their state constitution a prohibition on adopting the 19th Amendment. And then it came to this court, and this court said that this is a federal function and that substantive limit of the state constitution was inapplicable. So that's what we're dealing with here is a federal function.
But that was because it violated the federal constitution, not because it violated the state constitution. But let me go back to what I don't fundamentally understand about this case. The text of the Constitution of the Election Clause says, the legislature in each state shall prescribe the time, place, and manner of elections. We know that before the founding, at the founding of the Constitution, decades after it, even to today.
All right, y'all, that was a huge bomb right there. Hold on a second. Wait. We're going to go back just a few seconds.
We know that before the founding, at the founding of the Constitution, decades after it, even to today, that state constitutions have regulated time, place, and manner. We have the voice votes, we have one constitution that set elections at the courthouse and not in the county where the legislature wanted it. We have laws about voice votes as opposed to ballot votes. It seems to me that if I'm a textualist and I read that the legislature in each state shall prescribe the time, place, and manner of elections, that your argument would have to be that you can't regulate, the state constitution can't regulate that. But there is no substantive limitation in the Constitution. And the 10th Amendment says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. And if there's no substantive limitation in the Elections Clause, I don't know how we could read one in.
Your Honor, so I think there are a few points there.
It's a reserved power to the states to decide whether apportionment or malapportionment should be prohibited. We've already had a case, Grow, by Justice Scalia, who said that that was perfectly okay for a state constitution to prohibit malapportionment. Under your theory, the state constitution shouldn't have been permitted to do that substantive thing. So explain it to me.
Yes, so let me start with where Your Honor started, which was with the history. And we read the history very differently than my friend on the other side, because they point to
that was perfectly okay for a state constitution to prohibit malapportionment. Under your theory, the state constitution shouldn't have been permitted to do that substantive thing. So explain it to me.
Yes, so let me start with where Your Honor started, which was with the history. And we read the history very differently than my friends on the other side, because they point to 16 constitutions early in the founding of the Republic that they claim regulate federal elections. 5 of those relate to transitional governments. There was no state legislature, so it would have been impossible for the state legislature to adopt the first rules, and by their own terms, they were schedules that faded away once the state legislature had been elected. Then that leaves 9 which say that have regulations relating to—
There were only 13.
Well, I'm giving them credit.
There were 13 colonies, Counselor. If I got 6 of them doing something that's contrary to what you're saying, that seems like a fairly substantial majority to me.
Well, Your Honor, I'm going to get—
You can try to knock them down one at a time, but you're still with about 6 of them that can't be disputed.
I'm going to knock them all down with 1, so it'll be 12-1 in my favor by the time I'm done, Your Honor.
Yes, if you rewrite history, it's very easy to do.
I'm not rewriting history, Your Honor. What we're saying is that when it says all elections, it's referring to the offices that were created by that Constitution. You can see that in Vermont. It says all freeholders shall be eligible for office. It's not talking about the presidency of the United States because there's an age qualification. It's talking about
So why is it that in all of those states, the legislatures understood that all elections meant that you were going to have paper elections, ballots in both federal and congressional?
I think it is telling what those state legislatures understood. And if we look at Pennsylvania and Tennessee, they took those all elections shall be by ballot, and they promulgated 2 statutes to implement that, to implement and regulate their elections laws. For the state ones, they passed a law saying all elections shall be by ballot for the state races, and they cited back to those state constitutional provisions. And then they passed a separate law for the federal elections, and they did not cite back to that provision. Why not? Because presumably they understood that they were not bound by that, but they were simply trying to harmonize.
That is a large step, Counselor.
Mr. Thompson, if I could just piggyback quickly on Justice Sotomayor's question. At the outset, Justice Sotomayor said, pointing to the 10th Amendment and other structural assumptions of the Constitution, that we presume that states possess power unless they've given it up. So this is my question about the Elections Clause. If it did not appear in the Constitution. Would the baseline assumption have been that the states possess the power to regulate elections for federal office anyway? Because if so, I don't see how it's a delegation as opposed to a clause that clips state authority, perhaps by saying it must be exercised by the legislature and by giving Congress the power of override. But I wouldn't describe that as a delegation if the states had the baseline power to start.
Your Honor, in U.S. term limits, this court held, the majority held, that it was a delegation of power from the federal government. We understand that there are members of the court who take the opposite view, who say no, it was a reserved power, and it was, and it's protected by the 10th Amendment. And nothing in our argument today depends upon the resolution of that debate, which we understand is ongoing on the court. What we're saying is, regardless of whether it was a delegated power or reserved power, or maybe both, where they reserved it and it was given to them, regardless of how one resolves that, it is a federal function. That's what Lesser teaches. It's a federal function. And if we go back to the words of Alexander Hamilton, you look in, for purposes of judicial review, of what's the commission that this power is, and the commission means mandate. That's how Samuel Johnson defined commission, and the mandate comes from the federal Constitution. Your Honor, I'd like to go back to your question about structure. You know, you had asked me, where are we getting this distinction between substance and procedure? And I had mentioned precedent, and I had said there was a lawmaking function in the text. And I was getting to the structure. The structure is a familiar one. We obviously see the founders, in cases like Lesser, taking that pre-existing state legislature and assigning a federal function to it, but we also see it in state courts. State courts bound by state procedures, and yet having exclusive federal question jurisdiction until 1875. So this was a structure that was understood by the founders to take an existing entity with existing procedures, but to empower it to exercise federal authority, and that's what we see. And that's what Joseph Story in 1820, when he rises and eloquently speaks as to why there can't be a limit on the power, it's because it's a federal function. And I think Joseph Story's speech in 1820 is relevant too with respect to what do all elections mean, because the Massachusetts Constitution of 1780 had a provision that says all elections shall be free.
Can I ask you a question about it being a federal function? All right, so is it your argument that the state constitution has no role to play, period?
In terms of imposing substantive limits on the exercise of that federal function, that is our position.
So what procedural limits can the state constitution impose in this context?
Presentment would be a limitation. So Smiley teaches that if it requires presentment to the governor so that the governor can veto it, then that would be a procedural limitation that can be imposed by the state constitution.
Mr. Thompson, why doesn't Smiley stand for maybe a broader but simpler proposition, which is when we think about this word legislature, we're thinking about it as embedded in a system of constraints. And one of those constraints is the governor, and another of those constraints is the courts. And that's the normal way that legislatures operate and act, is as subject, not as absolute, but as subject to constraints. And Smiley said, we take that system as we find it. We take the constraint of the governor as we find it. Why not, too, then, the constraint of the courts?
We agree, Your Honor, the constraint of the court applying federal law. That's the teaching of Palm Beach County as we read that case. There was a vacatur of the Florida Supreme Court to send it back after having cited...
But it would be ordinary constraints, and the constraints can come from the federal Constitution, or the constraints can come from the state constitution. State actors, state courts, operate in both spheres and do both things. And that's the ordinary operation of the courts. And that's what Smiley says. It's the legislature subject to the ordinary set of constraints that operate on them.
We read Lesser to teach that when it's the ordinary constraint is federal law, that it's bound by federal law. That's the ordinary constraint.
Well, if that's coming from Lesser, I mean, so then you're going to sort of our precedent. And I would think that our precedent gives you a lot of problems. I mean, if you really take every statement that this court has said about the matter at hand, I'll just read you a few of them, and they're pretty recent. You know, Smiley is the one we've been talking about, and that says, just as Congress is subject to limitations in the federal Constitution when it makes laws, and now I'm quoting, there is no intimation of a purpose to exclude a similar restriction imposed by state constitutions upon state legislatures. And then in Arizona, we say nothing in the Elections Clause instructs, and this court has never held, that a state legislature may prescribe regulations on the time, place, and manner of holding federal elections in defiance of provisions of the state's constitution. And as to that point, the dissent was right with the majority, so both of them took issue with the proposition that legislatures would exercise their authority without the constitutional checks that a state court provides. And then in Rucho, 3 years ago, the court assured everybody in a case very much like this one. It was a case about gerrymandering. And it says complaints about districting need not echo into a void because provisions in state statutes and state constitutions can provide standards and guidance for state courts to apply in addressing gerrymandering. So 1, 2, 3, in all recent cases, we've said, of course, state courts applying state constitutions typically constrain state legislatures when they redistrict, when they enact election laws.
Let me start, if I may, with Arizona, Your Honor. In Arizona, the plaintiff was the Arizona State Legislature. The Arizona State Legislature did not make any complaints about the substantive restrictions in that referendum, and it's not clear it would have had Article III standing to complain about a constraint being placed on a different entity. So nothing in this court's decision went to the substance that was in that.
Yeah, I guess what I'm saying is that in each of these three, we have very clear statements, and I appreciate the fact that this issue was not the one before us in each of those three, just as it wasn't in the case that you mentioned to me that started off my quoting other things. If you're going to quote one at me, I'm going to quote three at you. And you're right, we're here for the first time dealing with this issue. This is a novel challenge. So I'm not saying that we've sat here as a court and addressed hundreds of pages of briefing on this challenge. I'm saying that 3 times in not so many years, we've understood this to be an established proposition of law.
So, Your Honor, let me now address Rucho, the most recent, where this court said, quote, we express no view, close quote, on these policy proposals. And many of the policy proposals that were identified in Rucho are ones that are fully consistent with the line we are drawing. The Rucho majority pointed to statutes in Iowa and Delaware that banned partisan gerrymandering. The Rucho majority pointed to a constitutional amendment in Missouri that designated and created the office of a state demographer to draw state lines. And essentially that's what we have here in North Carolina. Partisan gerrymandering has now been banned at the state level for the state races, and we're not here challenging that, and that presumably will have a salutary influence if the actual legislature itself is not gerrymandered. Then when it comes to the role of doing congressional races, and there were referendum, independent commissions were referenced by the Rucho majority, and we're not debating that, and Congress. And Congress just this session, the House of Representatives, which has more at stake than the Senate in terms of redistricting, passed a bill that would have banned partisan gerrymandering in all 50 states. And that's what the founders envisioned the solution to this problem was a political solution, going to Congress. It's right there in the text.
Counsel,
Go ahead.
you don't dispute that there could be judicial review by the state court of a federal constitutional violation.
Correct, Your Honor.
You don't dispute that federal courts and state courts can both review a provision for violation to the federal constitution.
Correct, Your Honor.
But you are disputing that the states can't review, state courts can't review a state legislative voting system to find whether it complies with the state constitution?
Well, it can for procedural reasons, like in Smiley, like if there wasn't presented to the governor.
So let's go to the substantive procedural reason still distinction makes no sense to me, because the only thing the Constitution, as I mentioned earlier, controls is the procedural issues, time, place, and manner. But take a line item veto provision, for example. In more than 40 states, these provisions empower governors to accept or reject legislation by altering its content. If, for example, a governor partially vetoes a bill to appropriate funds to administer congressional elections, is that a substantive constraint or a procedural constraint? Just a yes or no.
It's procedural.
Oh.
It's a hoop that has to be jumped through.
Okay. So the governor vetoes a map drawn by the legislature and decides it's constitutionally permitted. Why is it substantive?
We're not saying. We're saying if a governor, consistent with Smiley, if a governor vetoes...
No, the constitutional provision permits him to alter the content.
Oh, to alter the content.
That's
well,
what I said.
That's the key distinction. If it's a hoop that has to be jumped through in order for the legislature to get the code of elections it wants, it's procedural. If it's a limit on their substantive ability to get the code they want...
Is it yes or no? Can the governor do this?
Can the governor change the substance? No.
Yes. No. So that becomes substance instead of procedural. So your first answer has now changed.
A veto is
what about a
permissible,
state
changing the
constitutional
substance is not.
provision that precludes legislators from acting during special sessions on certain matters? Could a state court reject the congressional election bill if it is outside the scope of a special session? Yes or no?
If it's outside the scope of a special session, that is a substantive limitation because they can't start the process.
It seems to me it's procedural in its most common understanding because it's a question of how you do things, not what's in it.
If you can't start the process, then it's a substantive limitation.
It seems that every answer you give is to get you what you want, but it makes...
Season of the Urban Conservative podcast is brought to you by Newton for Senate, working to improve education, reduce taxes, and keep North Carolina #1 for business. Find out more at newtonforsenate.com.
Loath to enter. And I simply, what I don't understand is the question that Justice Jackson asked you, which is, if judicial review is in the nature of ensuring that someone's acting within their constitutional limits, I don't see anything in the words of the Constitution that take that power away from the states.
It comes from the fact that it's a federal function, and with respect to the legal morass, that's when this court has taken a functionalist approach. We're adopting a formalistic approach, and it's my friends on the other side who are adopting a functionalist test. You can see this on page 57 of the state respondent's brief.
Just following up on what was just mentioned, I guess what I don't understand is how you can cut the state constitution out of the equation when it is giving the state legislature the authority to exercise legislative power. It's the state constitution that is telling the legislature when and under what circumstances it can actually act as the legislature. So let me ask it this way. What if what is at issue is not any particular exercise of the state's legislative authority, such as its ability to make time, place, and manner determinations, but whether the entity that is purporting to exercise that power qualifies as this particular state's legislature. So you can imagine that we have two different state entities who claim to be the legislature for the purpose of the Elections Clause, and both of them start acting as such. They set election dates, they have procedures, they issue competing maps, and set out different statements about when elections would be held. Would that dispute, the dispute over which entity is really the state's legislature be decided by federal or state courts, and which law would apply?
It's state law. I think that's a lot of what was happening in Arizona, where the independent commissioning was saying, we're the
I'm
legislature.
sorry, state substantive constitutional law? We'd look to the state constitution to decide
Because
which entity?
well, it's a procedural issue as to who is the legislature, but
I'm sorry, why is that a procedural issue? My question is, we have these two entities, both of which say we are the legislature, quote unquote, of the state for the purpose of the elections clause. And there's a dispute about that. I think you're agreeing with me that that would go to the state Supreme Court. And I'm asking, wouldn't the state Supreme Court look at the state constitution and what it says about who gets to act as the legislature and what authority they have? Wouldn't it be looking at the state constitution to make that determination?
and that's what Arizona
I'm sorry, yes or no? Would it be
Arizona
looking at the state constitution or the federal constitution?
Arizona teaches that the states have the authority, wide latitude, to define state legislature how they want. This is a separate analytical question as just...
Okay, but what I'm trying to understand is why it's a different analytical question.
Well, because
to
the
extent that the state constitution tells us what the legislature is and what the scope of its authority, how it's supposed to act, what it's supposed to do, if that's a state constitutional issue, then what I don't understand is why aren't all of that entity's actions necessarily involving the state constitution? It only gets its authority from that document.
Because Lesser teaches exactly the opposite is true. In Lesser, the state constitution forbade Maryland from ratifying the 19th Amendment, and this court said it didn't apply that state
No, but
constitution.
that's because that particular issue was delegated to someone else. I'm talking about the authority of the state to act.
Well, Your Honor, under U.S. term limits, the majority of this court said that the power to act in this place, in this sphere, comes from the federal Constitution. Now, so the whole premise of this line of inquiry is faulty, but what I'm saying is that our position is whether the term limits majority or dissent was correct, it's a federal function.
Counsel, you make the point at several points in your brief about the nature of the state limitation that the courts were interpreting, a free election, a fair election. Is that a substantive argument, or is that just sort of a style point? Or, I mean, if they had a more precise articulation of what the limits were that they were going to apply, whether it's going to be a particular percentage of gerrymandering departure or something more substantive, is it the problem that they're just interpreting something that gives them free rein, or is that not a consideration?
Well, there are two problems, Your Honor, and so under our primary theory, the problem is that there's a substantive limit of any sort being imposed by the state constitution on the state legislature, but under our backup liability theory, the problem is that there is a lack of judicially manageable and discoverable standards, and that, as this court said in Rucho, judicial action must be governed by standard, by rule, and when the state Supreme Court was freed of standards and rules, it was no longer acting as the judiciary. It was taking legislative power, and the result of its work had the hallmarks of legislation, Your Honor. So it's both problems.
Mr. Thompson,
No, go ahead. Go ahead.
Mr. Thompson, even under your primary theory, however, isn't inevitable that there will be questions about the meaning of statutes enacted by the legislature to govern elections? So isn't it inevitable that the state courts are going to have to interpret those provisions? And isn't it inevitable that state election officials in the executive branch are going to have to make decisions about all sorts of little things that come up concerning the conduct of elections?
I'd like to make 2 points about that, Your Honor. First of all, our theory does not relate to the interpretation of statutes. Chief Justice Rehnquist's concurrence in Bush versus Gore was focused on that issue, and that's a separate issue. Under our primary theory, we take state law, however it's interpreted by the state Supreme Court, as given. And so there isn't a matter of having to, I just want to be clear, we're not talking about statutes, point one. Point two, under our theory, because this power has been vested in the state legislature, that there are non-delegation principles apply, and they can delegate this authority to local and state officials, and all 50 states have done that, but they just need to accompany it by an intelligible principle.
Well, if your theory doesn't apply to statutes, what would happen if all the provisions of the North Carolina Constitution on which the state Supreme Court relied were statutory? So there's a statute that says elections in North Carolina shall be free, and the North Carolina Supreme Court said, well, what that means is that there can't be any partisan gerrymandering, districting has to be done under one of these methods that we set out. That would be okay?
No, because that would be a violation of, there would be no standard, there would be no rule, and the state courts would be seizing that power from the legislature. I'm just pointing out here, Your Honor, we're not coming to the court on a statute, but that statute would be permissible, but not for this type of claim. So if there were some other claim where they said, well, the election isn't free because, you know, there's not one person, one vote. Okay, well, that's a judicially manageable standard.
Your position seems to go further than Chief Justice Rehnquist's position in Bush v. Gore, where he seemed to acknowledge that state courts would have a role interpreting state law, and that federal court review of that should be, in his words, deferential, and simply should be a check to make sure that the state court had not significantly departed from state law, and he drew on a body of precedent that has existed previously. And so I think the other side and the Solicitor General say that stands for a general principle, which they're okay with, that there can be some federal court review of state court review of state law, deferential, so long as there's no significant departure. That's a general principle. Why is that? Your position seems to go further than that, and where are you getting that out of Chief Justice Rehnquist's concurrence, or are you saying that was wrong?
No, Your Honor. What we're saying is that we have that was dealing with statutes, we're dealing with constitutions, and we have an even more deferential, a maximally deferential position. We say just take whatever the state Supreme Court says the law is, the substantive law is, just take it at face value. Do not examine in any way whether it is novel, a significant departure, an impermissible distortion. Just take it at face value and then assess, did it place a substantive limit on the state legislature? So we would defer entirely for purposes of our liability arguments in this court to and assume that what the North Carolina Supreme Court did here was correct.
And what do you think is the best case supporting this substance procedure distinction?
I would say Palm Beach County. I think the Florida Supreme Court.
Palm Beach County, I thought, was simply saying that there is a federal issue here, and we're going to remand to the Florida Supreme Court so that it can assess how to interpret its state law in light of the fact that there is a federal issue. I didn't, correct me if I'm wrong, or tell me what your position is, but I didn't see it doing a whole lot more than that. It was a 9-0 opinion, I think, just recognizing there's a federal issue.
Well, the court cited to and quoted from McPherson versus Blacker for the proposition that there could not be any limit on the power of the state legislature. Then it vacated the opinion of the Florida Supreme Court, and it sent it back on remand for the Florida Supreme Court to assess and to clarify whether it was in fact using the state constitution to operate as a substantive limit. And the Florida Supreme Court understood, because their prior opinion had gone on at some length.
Did it say substantive limit?
It said, it says, quote, operates as a limitation upon the state in respect of any attempt to circumscribe the legislative power, close quote.
Didn't use the word substantive, though.
Well, any limit. So maybe it's even more robust, but and would sweep aside.
Thank you, counsel. Just at page 33 of your reply brief, sort of the last gasp of briefing you have, you suggest that there's a, quote, narrower alternative ground to decide the case in your favor, which would allow some substantive state restrictions to be enforced. Could you articulate exactly what you think that is?
Yes, so for example, if the North Carolina Constitution had said partisan gerrymandering is cannot be allowed if there's an efficiency ratio of more than 7%. Then that would be a judicially discoverable and manageable standard. We all know how to calculate the efficiency ratio.
Well, let's stop. Okay. I'm sorry, go ahead.
The neuroscientist who drew these maps apparently knows how to draw the efficiency ratio. But in any event, that would be an example of a provision that would flunk our primary test because it would be a substantive limitation, but it would pass our backup test because there was judicially discoverable and manageable standards.
Thank you. Justice Thomas? Justice Alito? Justice Sotomayor?
I take your answer to mean that there are no judicially enforceable standards to interpret the freedom of speech, freedom of assembly, and equal protection clauses of the Constitution, because they on their face would appear to be as unmanageable or broad, and yet we routinely let federal and state courts review those acts.
No, Your Honor, that's not our position at all. Our position is you need to look at the type of claim. So take equal protection. That's sweeping and capacious language. And if it's the type of claim where you're looking to assess whether race is the predominant motive or whether there's a violation of one person, one vote, there are judicially discoverable and manageable standards.
Some of them were created by the courts. But
yes, with judicially.
And so what's different than what the court did here in North Carolina, where it looked to the meaning of the English Bill of Rights of 1689, which apparently was the basis for the state's constitution, and it said that the meaning was to curb royal efforts to manipulate parliamentary elections. It then looked to other states that had read in the free election clause and other clauses of the state constitution to find that political gerrymandering violated this term. How is that any different than what we normally do in our review?
Nothing in the English Bill of Rights told the North Carolina Supreme Court whether an efficiency ratio of 6, 7, 8, 9, 10% was acceptable. There is no.
You're not answering my question. Absent the election clause, is this term so unmanageable that you're saying that the North Carolina court would not have power to determine what free election clause meant in their constitution?
They would be exercising legislative power. It's just like Rucho. This is the exact same issue that divided this court in Rucho, and for the same reason it was a violation of Article 3, namely there were no standards, there were no rules, and so it wasn't a case or controversy. So to here, it would be an act of legislative power for a court to make this determination.
Justice Kagan?
If I could, Mr. Thompson, I'd like to step back a bit and just, think about consequences, because this is a theory with big consequences. It would say that if a legislature engages in the most extreme forms of gerrymandering, there is no state constitutional remedy for that, even if the courts think that that's a violation of the Constitution. It would say that legislatures could enact all manner of restrictions on voting, get rid of all kinds of voter protections that the state constitution in fact prohibits. It might allow the legislatures to insert themselves, to give themselves a role in the certification of elections and the way election results are calculated. So. And in all these ways, I think what might strike a person is that this is a proposal that gets rid of the normal checks and balances on the way big governmental decisions are made in this country. And you might think that it gets rid of all those checks and balances at exactly the time when they are needed most. Because legislators, we all know, have their own self-interest. They want to get reelected. And so there are countless times when they have incentives to suppress votes, to dilute votes, to negate votes, to prevent voters from having true access and true opportunity to engage the political process. And so I just thought, I would give you a chance to respond to that, because it seems very much out of keeping with the way our governmental system works and is meant to work. And I think if I could just connect it up to the last question that I asked, it's why in all these recent cases we have statements that say, of course, when the legislature acts, it's subject to the normal constraints. I mean, in this area of all areas, I guess I would add.
Your Honor, so our position is that checks and balances do apply, but they come from the federal Constitution and the panoply of federal laws like the Voting Rights Act and other statutes that are highly protective of voters. So there is a check, there is a balance, and there's also a political. So we've got the legal check from federal law, and we've got the political check that the founders envisioned of going to Congress. And as I mentioned, this very Congress, this House of Representatives, voted to ban partisan gerrymandering in all 50 states.
Thank you.
Justice Gorsuch?
And on that history, in terms of checks and balances, what sorts of concerns might the founders have had with if state constitutions were allowed to trump over state legislatures?
I think there are two, and we can learn them from James Madison and Joseph Story. So James Madison, as I mentioned, specifically singled out South Carolina as a place that had taken its gerrymander and entrenched it right into the Constitution itself, and of course Virginia in 1830 does the same thing, where the slave owners try to aggrandize their political power by putting a partisan gerrymander right in the state constitution. And there's nothing anyone in the state can do about it, short, of course, of amending the Constitution or coming to Congress. And the flip side of that is what Joseph Story in section 820 of his commentaries on the Constitution says, which is, he calls it a boon that the state legislatures have this, what he said on the floor of the Massachusetts Convention, unlimited discretion. The boon is because they have adaptability to what he said were local politics, local convenience, and you don't have that adaptability when it's in a state constitution.
Subject to federal constitutional constraints and federal court review and state court review of federal constitutional claims.
Absolutely, Your Honor.
And historically, at least as I've looked at it, you've got the example of Virginia trying to constitutionalize a 3/5 rule with respect to African Americans.
Yes, Your Honor, exactly right.
You've got the example in Maryland of trying to deny the opportunity to adopt the 19th Amendment to the Constitution.
That's right, Your Honor.
And I believe during the Civil War there were examples as well of states that in their constitutions would not have permitted absent soldiers from voting in their home state elections, but for the fact that state legislatures refused to follow those rules.
That's right, Your Honor. And the Supreme Court of New Hampshire, the Supreme Court of Vermont took this up and said these state substantive limitations, they do not apply because it's a federal function.
So the political saliency point, I think, it depends on whose ox is being gored at what particular time. I wanted to just make sure I understood your colloquy with Justice Kavanaugh, and I believe the Chief Justice too. The difference between this and the Bush versus Gore circumstance that Chief Justice Rehnquist spoke about in his concurrence. It seems to me there are two types of problems. One is the state court actually interpreting a statute, or is it going too far afield to the point where someone might say it's not following the statute?
Yes, that's the Bush versus Gore concurrence problem.
And then you have a separate problem of when a state court does not even try to interpret the law. and just annuls the law outright, and that's this case.
I actually
Or am I
frame it
wrong about
differently.
that?
I think respectfully, Your Honor, you are, because even though we actually think that's an accurate description of what happened here, that's not our position in this court. Our court is assumed that the North Carolina Supreme Court was entirely right about what they did, and that it was
As a matter of state law.
as a matter of state law, but that it is then still impermissible because it is imposing a substantive limitation on the state legislature.
Via this melange of constitutional provisions.
Yes, Your Honor.
Okay, all right, I understand it now. Thank you.
Thank you.
Justice Kavanaugh?
In interpreting the state statutes, can a state court rely on canons of interpretation that say interpret those state statutes in light of state constitutional provisions?
Your Honor, so what Chief Justice Rehnquist said in the Bush versus Gore concurrence was, he said, look to the novelty. Look to see whether, when you look at the text, you look at the canons of construction, you look at any other sources, a precedent, you look at all the panoply of different tools available to state court judges, and if it would be a surprise to someone that this is what the statute meant, he had a novelty test. And so that would be the way you would do it. Of course, in this case, that's not...
Is that a yes to the question?
Well, Your Honor, yes, you would look at state canons of construction in that very different context.
Which could be rooted in the state constitution. Earlier questions have pointed out some of the early state constitutions did that. What do we do with that historical practice in thinking about how to analyze this question?
At the time of the founding, the original 13 states, our view, properly understood, was that there was only one state that did it. It was Delaware. It was an outlier. There was no debate whatsoever about the elections clause, and it said that, voting will be by ballot.
What about the historical practice over time, which has certainly developed in a way that state constitutions do regulate federal elections? What weight, if any, do we place on that? Also, there's some federal statutes as well that are cited by the other side, and just want to make sure you've had a chance to talk about those as well. So the historical practice in the states and those federal statutes.
Your Honor, we think the way to think about this is consistent with the court's opinion in Bruin last term, where it looked very focused on the time of the founding, 1791. Obviously, we're looking for the public meaning of the Constitution as that founding generation passes away. Adams and Jefferson die on the 50th anniversary of the Declaration of Independence. As we get out of the 1820s, there's very limited information you can get as to the original public meaning of the Constitution. But so it can be a confirming that subsequent history, as in Bruin, can be a confirming historical tradition, but it can't undermine what the text and the founding era history show to be the case.
Thank you.
Justice Barrett?
So could you, I'm going to follow up on Justice Kavanaugh's question about Chief Justice Rehnquist's concurrence in Bush versus Gore. So I understand that that's not this case because that was an interpretation of a statute and we're talking about a state constitution. But I take it that if we were talking about an interpretation of a statute, you would agree with Chief Justice Rehnquist's approach?
Yes, we do agree.
And on the theory that at that point the state court would not be acting as a court but would be acting more as a legislature?
That's right, Your Honor. I do want to point out that if the court were to rule in our favor in this case, it would not necessarily follow that it would have to rule the same way as the Bush versus Gore concurrence for this reason. Statutes are always less problematic under the Elections Clause because they can be repealed, they can be rewritten by the state legislature. So by definition, a statutory and impermissible distortion of a statute it can be remedied by the state legislature. Now, it couldn't in Bush versus Gore, there wasn't enough time, but the point is, and we think the concurrence was correct, but I just wanted to make the point that it does not necessarily follow that if the court rules in our favor in this case, that case would come out the way the concurrence did in Bush versus Gore.
Well, I have a question that follows up on that, but before I move to that, I just want to ask you quickly. So if we're asking about novelty, if we're asking about an egregious departure, or if we're asking about the distinction between substance and procedure, those are kind of all notoriously difficult lines to draw. But in your colloquy with Justice Sotomayor, you were talking about the lack of judicially manageable standards for, say, free and fair elections. Why do you think that that's less judicially manageable than, say, deciding whether something is substance versus procedure or an egregious departure, truly novel?
Well, just to be clear, Your Honor, so in terms of figuring out whether there's been an impermissible distortion of a statute, that's where you have to look to see whether it's novel.
Right, but I thought you said you agreed with that approach.
I do. I'm just saying that in this case, none of that is implicated.
I understand that.
Yeah. Okay. And so I apologize.
Well, I think substance and procedure, as many of the questions that you've gotten indicate, are difficult to separate out. And so I'm saying you're leaning pretty hard on the lack of judicially manageable standards for things like free and fair elections. So I'm saying, why should we take solace in a substance procedure definition as a more manageable line?
Well, thank you, Your Honor. And I would point to the court's decision from 1946, Murphy, where it is talking about the Rules Enabling Act, and it's setting up the line between substance and procedure.
Which is, as a former civil procedure teacher, I can tell you, is a hard line to draw and a hard line to teach students in that context as well.
Well, and the court could take a functionalist or a formalistic approach, but we're saying take a formalistic approach, say that if it is a hoop that needs to be jumped through, then it is procedural. And if it's an effort to limit the content, and this is an easy case, that this is obviously substantive because there was a map and it was thrown in the trash by the courts. And so this isn't even close to the line, but we think my friends on the other side, they're trying to adopt and asking the court to adopt a functionalist approach. They say on page 57 of the state respondent's brief that yes, there's something to this idea that that there are limits on the extent to which the state constitution can control the state legislature. The state legislature has to have, quote, a central role, close quote. That is a functionalist test if ever there was one. And how do you define the center, and how far from the center can you go? And oh, by the way, if this is in the center, then the center is pretty much coterminous with the circumference, because we've been sidelined. Completely.
I'm sorry to cut you off. I just don't want to take too much of my time. I just want to ask one last question. You were pointing out that state constitutions entrench norms, and so they're more problematic than statutes.
Yes.
But a lot of state constitutions can be amended by simple majorities in, say, the referendum process. And so, we know from Hildebrand that if a districting is done by referendum, that's okay. That doesn't violate the election clause. So why is it any different, say, if a state constitution is amended and some substantive provision is added by referendum, but it would be problematic? Why is that problematic? When it can be changed by a simple majority, why is that more entrenchment? And why would we say that having it appear in the Constitution is problematic when, if it appeared through the referendum process and the legislative process, it's not?
Well, respectfully, Your Honor, if we're trying to get at the original public meaning of the Constitution, I think everyone agreed in Arizona that these referendum were unknown at the time of the founding. And so James Madison was...
But you're stuck with Hildebrand. I thought you weren't trying to get rid of it.
I'm not trying to get rid of it, but if we're trying to say why would the founders have objected and been worried about partisan gerrymanders in a state constitution, they would have been worried about it because it was maximally entrenching. If the question is, why would they have drawn the line the way they drew the line, that I'm saying they drew the line, is because Madison was worried about entrenchment in the state constitution. And some states may have this procedure, others don't. But typically, if you want to try to solidify something to the maximum extent possible politically, you typically put it into a constitution.
Justice Jackson?
Yes. Excuse me. Do you agree with me that the Elections Clause doesn't take any position as to who the entity in the state is that qualifies as the legislature?
We think the dissent in Arizona was correct, and that the legislature meant the legislature plus the gubernatorial veto.
Legislature defined by whom?
Well, I would point the court to Samuel Johnson's definition, where he said the three branches of the legislature.
So not the state constitution. They doesn't. I mean, I read the elections clause as essentially giving the entity, whoever it is, that is the legislature, the power to make this decision, but not taking a position as to who the legislature is.
And that is what the Arizona majority said, and we're perfectly content to abide by.
Okay, so if that's true, if it is the state's constitution that it tells us who the legislature is and whether what they're doing is a valid exercise of legislative authority, then I guess what I don't understand is why constitutional limits on the exercise of that entity, on its power, don't still apply, even in this context. So in other words, the elections clause says you get the right to make this decision. You have that policy determination. But the state constitution is the thing that gives this particular entity its authority to make any determinations. And the state constitution says things like, when you make a determination about things in your policy-making role, in the legislative power that we're giving you, you have to make sure that people are treated equally. You have to, whatever the constitutional provisions are that we say, that you're saying are so vague or whatnot, are limitations on that entity's legislative authority, not just in this area, but in every area, whenever they undertake to make a law. And so I guess what I'm trying to understand is, why are you suggesting that in the context of the elections clause, when this entity would ordinarily be bound by all of the limitations in the state constitution in its legislative authority role, why suddenly in this context do you say, no, 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 all those other constitutional provisions that would bind or constrict legislative authority that the state gives you because you're the state legislature, right? Why do those evaporate in this world? I read it as though the state court is essentially saying, our Constitution authorizes you to be the legislature only insofar as you act in accordance with our Constitution's tenets. And you haven't done that in this instance. Why am I wrong about sort of conceptualizing it in that way?
Because it's a federal function, and that's what Lesser teaches. So there was a constitutional prohibition on the Maryland legislature allowing women to vote. And
no, I'm asking, when you say federal function, I guess maybe that's where I'm getting hung up. I thought it was a determination, a delegation of, policy-making power in the sense of you get to make this decision. But the authority for that body, wherever it is, that's called the legislature, comes from the state. Because, that was my example about we have two different entities in the state fighting. Who's the legislature, right? It's what the Constitution of the state says that gives you the power, entity X, to be the one who is the legislature making this elections decision. If I'm right about that, then what is being delegated from the federal Constitution is not your power as a legislature. It is just delegating to you the decision about time, place, and manner, which is fine. But you have to do that consistent with the authority that you have as an entity to make legislative decisions. And that comes from the state constitution.
And U.S. term limits says that is not right.
All
That
right.
the premise of your question is not right.
All right, thank you.
Thank you, counsel. Mr. Katyal?
Thank you, Mr. Chief Justice, and may it please the court. For 233 years, states have not read the elections clause the way you just heard. There are two reasons to affirm. One is that when enacting legislation, there's no such
TV, bridging communities worldwide. We broadcast diverse international content from Europe, Asia, Africa, and now right here in the USA. Watch us via Roku on your smart TV. Submit your own content to 1530entertainmentllc@gmail.com. Download the Millennium TV app from the App Store to stream our shows anywhere, anytime. Millennium TV.
Thing is an independent state legislature. The other is that North Carolina statutes authorize what the North Carolina court did. I'll focus on the first. Petitioner's idea that state legislatures created by state constitutions are independent of them is wrong. It is rejected by the Articles of Confederation, rejected by the early state constitutions, rejected by the founding practice, especially in New York, where judges vetoed federal election bills. It's also rejected by this court in cases such as Smiley and Hildebrandt. Just 3 years ago in Rucho, this court promised state constitutions can provide standards for state courts to apply, and singled out for approval a Florida court decision that used a state constitution to invalidate a federal map. To accept petitioner's claim, you'd have to ignore the text, history, and structure of our federal constitution, as well as nearly every state constitution today. Petitioners say for 2 centuries, nearly everyone has been reading the clause wrong. That's a lot of wrong and a lot of wrong past elections. Frankly, I'm not sure I've ever come across a theory in this court that would invalidate more state constitutional clauses as being federally unconstitutional, hundreds of them from the founding to today. It's worth taking a pause to think about what petitioners are saying. They claim the word legislature means a species of state law that has literally never existed. State lawmaking unconstrained by a state constitution. If the founders intended to create that animal, surely someone would have said something. Finally, the blast radius from their theory would sow elections chaos, forcing a confusing 2-track system with one set of rules for federal elections and another for state ones. Case after case would wind up in this court with a political party on either side of the V. That would put this court in a difficult position instead of leaving it to the 50 states.
Mr. Katyal, would you spend some time on discussing the source of the state court's involvement in a federal election?
Yeah,
I understand the court is created under state constitution, but this is a federal matter.
Correct, and we, for reasons Justice Kavanaugh said, Your Honor, think that Palm Beach basically says there is some sort of federal issue here with respect to elections clause, and we think obviously the state court got it right and didn't violate the elections clause, but we think that's the source of authority here. And Justice Thomas, if I may, in 2 decades of arguing before you, I've waited for this precise case because it speaks to your method of interpretation, which is history. And the founding evidence here is overwhelming, and I point you to 4 things. First, the Constitution uses the same word, legislatures, as the Articles of Confederation, and 10 of state constitutions under the Articles regulated federal delegates. Second, after the Constitution was ratified, states kept regulating it. States like Delaware and Maryland and Mississippi expressly regulated federal elections, as did 3/4 of the states. Third, New York in 1792. This example is really important. I think it's truly action as opposed to the talk from Schuyler and Justice Story. In 1792, the Council Revision, which has 4 people on it, 3 judges, 1 governor, vetoed a federal elections bill for the selection of delegates to the House of Representatives. It was a time, place, manner thing. Why did they veto it? They said because it is, quote, repugnant to the state constitution. That is very strong evidence. That's exactly the example you used in Smiley to build your decision there. And lastly, and most importantly, the dog never barked. The Federalist Papers have 3 different Federalist Papers on everything he's been talking about the Elections Clause. Not a person said anything like that they were trying to create this strange animal. This isn't looking like into a crowd and trying to pick out your friends. This is like looking into the Lollapalooza crowd and picking out everyone who speaks 15 languages.
I don't know about Lollapalooza. But while we're looking at crowds, Mr. Katyal, I'm sorry, Chief, you want to go ahead?
No, go ahead.
You want to touch the Lollapalooza, yeah. right? That was a Lollapalooza. It is a small point, but on Smiley, on the veto question, just narrowly on the veto question, Locke, Montesquieu, Federalist Papers treat that as a legislative power and a sharing of the legislative power. And it's in Article 1, which kind of suggests the founders considered it a legislative power. So I guess I'm a little less moved by that Lollapalooza than you are. Maybe you can help me out, though.
Sure, of course. And I think it's reflected in the Chief Justice's comments to my friend on the other side. There is certainly something legislative there, but I think that the overall point of Smiley is to say, and my friend says this in the reply brief at page 6, you take legislatures as you find them. He agrees with that proposition. That's what Smiley did as well. The legislature, as it was found in Minnesota in Smiley.
And nobody here thinks the North Carolina Supreme Court is exercising a legislative function. We all agree on that too, right?
Correct.
Okay, so that kind of takes care of that argument.
Well,
doesn't it?
No, because I think underlying Smiley is something more specific than that. It's basically saying that the conditions on the lawmaking power, that's the language at page 365, apply. And certainly one condition on the lawmaking power, only in 2 states at the founding, but more at the time of Smiley, was the governor's veto.
Yeah, and that's because if we want to look at our friends in the Federalist Papers and everywhere else, that was considered sharing of, there was no absolute separation of powers. There was an exception that they had to be mixed. You know your Federalist 47 and 51 better than I do, I'm sure. But that was a legislative function that was given to the president, and there it is in Article 1.
Not disagreeing with that, okay. Justice Gorsuch. Right. What I am saying is that Smiley focused on 2 things, the word legislature, but also the word regulate. Right. And together they create a lawmaking system, and what Smiley says is you're then subject to the constraints of that lawmaking system, one of which was judicial review, well established at the founding, far more established than the veto.
Now we're off on another tangent. Go for it.
So far more established than the veto. And so, 7 different states had judicial review at the founding. If the method of Smiley is to say, look, the founders knew about the veto because it was in 2 states. Did they textually exclude it in the language? The answer was no.
Mr. Katyal, I don't hear your friend on the other side really questioning now, at least, whether there is judicial review. I understood his primary argument to be, even though the states, we agree, he says, can come in and look at this, what they have to be doing is applying federal law. And so that's the part that I keep getting hung up on. Can you help? I mean, we have said at certain times here in the questioning today that various entities are exercising legislative power or not, or maybe the court is exercising legislative power. I thought we were able to tell when something is a legislative power by reference to the state's constitution, that they tell us when legislative power is being exercised at all, validly, or whatever. Am I wrong about thinking about it in this way?
You're absolutely right, Justice Jackson. So 2 points. One, we can't figure out what petitioner's theory honestly is. What they just told you is the opposite of what they started with on page 1 of their brief, where they said state courts have no role. They said legislature means legislature, but then you get caveat after caveat. It includes governor. It includes referenda. It includes independent commissions. In the reply brief, they say, then they say, well, but state courts can't do it, but maybe they can for federal review. Maybe they can if it's procedural or non-abstract. I mean, the one thing we know, they're not making a textual argument anymore. Now, with respect to this federal function argument you were asking about, Smiley dead rejects it. That's exactly what the Minnesota Supreme Court said below. They actually called it a federal agency. And what this court did, unanimously reversed, and it said no, because here you are acting, quote, as a lawmaking body, which is what I was saying to Justice Gorsuch from page 364. It's the exact opposite of his example of the Lesser case. Lesser is about Article 5. It's about a totally different text. The text of Article 5 is application of the state legislatures. The whole point of Smiley, Justice Jackson, is to say this is different because it's a lawmaking system, not just because of the word legislature, but also because of the word regulation. There is no regulation that has ever existed that has been exogenous to the state constitution. It's literally a species that never existed.
Mr. Katyal, can I ask you some questions about the boundaries of your argument? So suppose a state constitution says that congressional districts will be determined by the state Supreme Court exercising legislative power. Is that consistent with the Elections Clause?
We don't think it would be, Your Honor. So we think, in general, there may be some redefinition of the legislature that the Arizona decision might permit. That isn't what we are arguing here. We're talking about ordinary checks and balances like judicial review.
All right, suppose that the state constitution says that the legislature can adopt congressional maps, but in that instance, the state Supreme Court shall sit as a council of revision to determine whether the maps are fair.
Yes.
Is that okay?
We do think that the history there would suggest it is. Nothing in our argument, of course, depends on it. Again, ordinary judicial review, that is all we think you should reach in this case. Not that, but the New York example.
Well, that's
exactly
not really
that.
judicial review. That is because they're not reviewing it for anything. So what was your answer there? That is okay or that is not okay?
Nothing in our position depends on it, Your Honor, but the historical test, which is what he's using, New York in 1792, did exactly that.
Well, I'm not sure I understand your argument, but okay, on to another example. Suppose the state Supreme Court says the essence of our state constitution is fairness, and we don't think that the map adopted by the legislature is fair. Is that okay?
The Constitution says that the map adopted by the legislature is, or the state court says that?
The state Supreme Court says that the essence of our state constitution is fairness. It doesn't point to a particular provision in the state constitution. It just says the essence of our state constitution is fairness to all of our citizens, and the map adopted by the legislature is not fair.
Yes, Your Honor. We think that would, again, nothing turns on that here, but the answer to your question is yes, we think that'd be constitutional. And the reason why is because there's a trident of safeguards that would prevent any sort of abuse. The first one, the safeguard, is in the state process itself. As Judge Sutton's work explains, state courts have all sorts of mechanisms to restrain them, including popular accountability. And as Justice Barrett pointed out a moment ago, a much easier amendment process.
Well, that's a little bit off the point as far as popular accountability is concerned. We have seen examples of many state Supreme Courts are elected, and some states allow partisan elections. So there's been a lot of talk about the impact of this decision on democracy. Do you think that it furthers democracy to transfer the political controversy about districting from the legislature to elected Supreme Courts where the candidates are permitted by state law to campaign on the issue of districting?
Yes, Your Honor, we do. And the reasons for that are threefold. Number one, there are any number of checks on that process, including, as Justice Barrett says, the amendment process and other things that Judge Sutton warns about. Second, the founders placed into the Elections Clause itself a specific remedy for your concern, which is that Congress can come in and supplant any particular state court decision they don't like. They can say this North Carolina map should be reinstated. They could supplant all the state constitutions.
Well, can't you say the same thing about allowing the legislature to do, which is popularly elected, to make the map? Congress can always come in.
Sure, and that's exactly what Smiley and Smiley rejected, this idea that that's the one remedy in Westbury as well. They said that's just indicia of the fact that founders distrusted state legislatures and wanted checks and balances. Here, of course, we're only seeking an ordinary one. And third, with respect to your question of the catastrophic consequences, we think, for reasons Justice Kagan said, that cuts entirely the other way. I mean, the blast theory, by their theory, blast radius by their theory, starts at the size extra large. It starts with invalidating 50 different state constitutions today. Elections clauses are in 27. All states have equal protection clauses, speech clauses, assembly clauses. 30 of them guarantee the right to a secret ballot. There's 5 of them voter ID.
What about the approach set out by former Chief Justice Rehnquist? Is that also a Lollapalooza? Does that have a huge blast radius?
No, Your Honor. As long as we understand